He's one of authors of report Climate Laws in Europe, Good Practices in Net Zero Management. And through the findings of the report and identified good practices, he will focus in particular on three key elements of climate law: planning and measures, progress and monitoring, and institutional arrangements. And also based on those findings and other knowledges, he will comment on the draft of Slovenian climate law and maybe even provide us with some suggestions for potential improvements. So Matthias, thank you very much, and word is yours.
Well, thank you very much, Taj, and everybody at Focus for the invitation. I'm really happy that I get a chance to present the report in all its minute detail. It's my first chance that I'm getting, so I'm particularly happy about that. Let me check that the technology is working well enough. Sorry, this will take maybe a second or two to get us off the ground. Okay, so you basically covered well what I will be focusing on. I should maybe say that the report is also in its last chapter attempting to apply some of the lessons and the good practice insights from the national laws in Europe to the EU level, where a proposal for a European climate law was just revealed yesterday and adopted by the European Commission. I'm not sure that we'll necessarily have time to focus on this today, but that's also something you'll find in the report, and I do have some slides if we have time for it. First off, to say that this is work that I've done together with several colleagues at Ecologic Institute, most notably my colleague Nick Evans, who's also a co-author. It's work that was funded by the European Climate Foundation, and we're very grateful for their support and all of the help and the contributions that we've received from the individual colleagues there. And it is also benefited from inputs provided by national experts from around Europe, which we are also very grateful for, including the likes of organizations that you've had in previous webinars here. So there's a separate summary, which is giving you the short version and then a more detailed full report. And I should say that it's building on work that we've been doing for a number of years now, looking at climate governance frameworks at various levels, including with a focus on subnational and the national level, but also especially through my colleague Niels Meyer-Ohlendorf, also for a climate law for Europe. And we've also closely monitored and observed the negotiations on the governance regulation for the European Union. The laws that we've actually analyzed for the results or insights that I can present to you today, there were 9 of them, although there are more overall, but we focused on 9, those being 8 member states of the EU: Denmark, Finland, France, Ireland, Sweden, the Netherlands, Germany, and Spain. And then as former member states, the United Kingdom, who with its Climate Change Act from 2008 was the original pioneer, the grandparent to many of the laws that followed. And many of the laws that followed, I should say, with a focus also on the long term. So this is one of the innovations that the UK Climate Change Act brought, was a 2050 target and working towards the long term. And in our report, we've also focused on laws that all have that long-term dimension. I should point out for clarity that Spain was a draft of a law that we looked at. Same for Denmark, where the existing law from June 2014 is set to be replaced by a new law that we analyzed in its draft form. And this similar situation exists in Ireland, where there's also a major revision plan, but we did not consider the contents of the draft bill that was published earlier this year for this report just yet. So let me get into some essential backgrounds that actually segues quite nicely from which countries we were looking at, because I think one of the things to know when you're looking at developing a national law now in Europe is that the majority of EU member states already has a framework law or is preparing one. And so this is a map that tries to visualize the different categories of laws that exist and the different statuses, and includes, of course, among the ones that are preparing one, Slovenia. Although I'm aware that you know, this process may or may not go forward depending on future government action. So there are several laws that do not actually yet have the long-term perspective that I was just focusing on, such as Austria, for example, which was an early adopter of a climate law, but which drafted its law to be focusing more on near-term targets. The same is true for Bulgaria and Malta, where laws exist, but they don't have that 2050 or 2045 or 2040 perspective. So this, from our perspective, was a qualitative distinction, because we're seeing that especially with the adoption of the Paris Agreement, there's a clear uptake in the number of governments that are adopting new governance systems, and largely or almost entirely are doing so in the form of national climate laws. And so there are a number of the ones that have also been adopted in the EU that were, in the time frame of 2014, 2015, such as Denmark, Finland, and France, for example, or in the immediate aftermath of, Paris with Sweden, for example, and last year alone had the Netherlands and Germany, for example. And it's the Paris Agreement, I think, that's helping put a focus on the long term with its long-term temperature goals, and the request for countries to prepare long-term strategies. And so this is this new awareness of we're not just talking about incremental change for the next 5 to 10 years, but we really need to consider and put in place systems that can help us get to the long-term change that we require. I think that's a qualitative difference in the new sets of laws. And I think one of the things I want to focus on is as background that from our perspective, and also seeing what's in the national laws, that a key need here is for governments to put in place management systems to help guide action towards those long-term targets, because their existing structures are not really well equipped for that. So many policy areas that are usually dealt one by one, by respective ministries, they're all affected by the need to go to net zero emissions and beyond. And so a key question one can ask, in fact, is what is the added value of actually doing this in the form of a law? Because you can, in principle, of course, envisage that there are also just governmental declarations that are saying we're putting now in the future in place these procedures to help us work towards the long-term target. But the systems that are being adopted in Europe, for sure, are essentially in the form of laws. And so why is that? A key added value is it's harder for governments, especially after elections with maybe new political majorities, for governments to go back on the promises of a previous government. Having these procedures and targets in law create an additional hurdle towards a rollback in policy. They are also a statement of the sincerity of governmental action. So it's a signal to external stakeholders and also the governmental actors to say, we are really serious about implementing and working towards these targets. And we're showing that by doing the most concrete and stable thing we can do, which is put it in a law. And it clearly helps with the professionalization of political structures, because you can establish legal responsibilities and assign roles to individual actors. Now, especially, this idea that having a law, prevents a rollback, of course, can easily be challenged if you say, but I mean, any future government can change also, a law. That's an essential function of our democracies, that, we vote for a new government and, we get slightly different policy. And so that's why it's important to point out, certainly for the laws that we were looking at in this report, there's really broad political support for the concept of having such a law, and for also, in most cases, the specific system that was adopted. And that's not a historical anomaly, or it's not an accident. In many cases, this was part of the development and adoption process. Let me just take the most recent example from Denmark. There was indeed a change of government last summer, but the parties that were able to form a government essentially reached out to others to form a cross-party and consensus on the essentials of what the future climate law should contain. Specifically, and the minister responsible for that said, specifically so that a change in government will not affect these structures that we're putting in place. So I think the results that we're seeing from that are actually showing that there's more stability across electoral cycles with these systems, because they are based on broad political support. Now, getting into the core elements that Taj already alluded to in his introduction to the presentation. We started off already on the basis of our pre-existing work and established that we wanted to look at certain categories for our analysis. And those are, to our understanding, essential functions that climate laws need to fulfill. They're the supporting government in and related stakeholders in helping to answer key questions around how to manage your climate policy. Rather obvious one is what is it actually that we're setting out to achieve? What are our targets? Putting those in the law, makes a lot of sense, knowing what your direction is that you're working towards. On that basis, then, from those targets follows, so what are we doing to get there? And that means charting out strategies towards your objectives, and then identifying the specific policies and measures that are going to help you create the change in the real world that you want to see. And then the third element of that cycle is basically, so we've got our targets and we've planned and put measures in place to reach them. How well are we actually doing? You need procedures to get you that information, so that you know whether what you're doing is sufficient. And on that basis, you can close that cycle and help that information inform in some way or another, do we need to adjust or review our targets, our strategies, and our policies. Then I did mention already the professionalization of governmental structures. The key question in all of this is, so we're putting in place a new and maybe a clearer process and system. So who is doing what? That's a key question that national climate laws can help answer, or give government a space to write down who is doing what. And then there's, of course, the question, who else is actually being involved? And this is where, on the one hand, additional analytical and scientific input can be provided, but also where public contributions and stakeholder input are potentially something that can be brought into all of the elements that are in the main cycle. Having shown you that those are the elements that we were looking at and trying to figure out how the national laws are dealing with them, let me go now through the essential ones bit by bit, starting, of course, with the targets. And here we clearly see from the 9 laws that we were looking at that essentially all of them are enshrining quantitative long-term targets. There are only two exemptions, really. One is Ireland, who in its currently still applicable law only has a qualitative target. It's something about, you know, achieving a low carbon economy. It doesn't have a more specific emission related goal. And Sweden is the other example, but there it's not necessarily, oddly, a weakness. So in Sweden, the long-term law is, long-term goal, my apologies, is not written into the law, but instead it was, there's a process in the law for Parliament to adopt the target. And so what happened actually was that the law was decided in parallel and alongside the long-term target on the same day as part of a new Swedish climate policy framework. So the long-term target is there. The additional question is, of course, what are the steps towards that target? And so this is where some laws actually mention interim targets directly. I think that's good practice. And then there are some laws that establish processes for setting future targets on an ongoing basis. And the most well-known, I think, an emulated process is that concept developed for the UK Climate Change Act of defining 5-year carbon budgets with a good 10 years into the future. To know always you're setting concrete steps on your path towards 2050, but you're not doing it just for the next 5 years, for example, but you're doing it now for a period in the future to get some more specification and clarity about what exactly are our targets along the way. And this is basically be done every 5 years as a rolling target setting system. And this is an approach adopted also in France and being considered for Ireland. And Germany has a very specific version of these carbon budgets, which are not necessarily the same as the 5-yearly ones set in advance. But Germany is using a carbon budget approach to break down its 2030 targets into sectoral targets and monitor them on an annual basis. Several countries also include non-greenhouse gas targets, such as for renewable energy or energy efficiency. And some include a review process, specifically saying on the basis of additional information or developments at EU or UN level, we are going to give ourselves the opportunity to adjust the long-term law. But on the basis of criteria, or as is the case, for example, in the German and Spanish law, those are saying there is no backsliding here. We cannot weaken the existing targets. If we're changing it, it can only be to strengthen the target. Now on to planning and policies and measures. I'm going to distinguish between the two, although that distinction is a little awkward. There are actually EU legislative obligations for all EU member states to basically have both elements. They have to have long-term strategies, and they also have to have national energy and climate plans, which basically fulfill these two functions. Long-term strategies are for the long term. They are less specific in terms of measures, whereas the national energy and climate plans are for the coming 10 years, and they should have a lot more detail and specific policies. In the laws that we analyzed, that distinction is not always made in that same concrete fashion. So, which makes the analysis a little harder. There are a couple of countries that are basically blending these functions to some extent. You could say that that's true for Ireland, for example, which has a long-term strategy that also should have all the policy detail, for example. Or the UK has also only one strategy document. It's a strategy for the most advanced or the carbon budget that's most in the future. So, 10 to 15 years in advance, but it's clearly referenced to be in line with the long-term goal. So it's not quite straightforward. What we can pick out here is there are a couple of countries that are quite clear about making this distinction, and I think that's a useful way of going about it, especially considering that there are these EU legislative obligations anyway. Finland, for example, has a clear hierarchy in its climate planning system. That's a literal quote from the law, at least the translated version of it. And so it has this long-term climate strategy, and then it has a medium-term plan as well. And the same is a distinction you find in the majority of laws, but it's not always all that clear-cut. Then with regards to measures, this is where we then see the other end of that blurring of the lines. Most of the laws really have regular policy development processes. So policy packages or programs or climate plans. The terminology varies and is not very specific. And a lot of those are basically for the time periods of the next 10 or the next 15 years. So somewhat similar to the national energy and climate plans that I already mentioned. But interestingly, only the Spanish draft law referenced specifically saying, we're going to use this NECP, this National Energy Climate Plan, and we're going to make it our policy development vehicle or instrument. With regard to measures, two other elements that I should say, that I should mention. Both the French law and the Spanish law are special in that they contain a number of specific policies directly in the law that already also contains all the framework and the system. So in Spain, for example, it is envisaged that there should be a ban on combustion engine vehicles for at least private ones and light duty ones by 2040. In France, there are emission standards for thermal power plants, which essentially mean that coal power would be phased out over the near future. And these things are directly in the same laws. Most of the other laws do not have such specifics directly integrated. But what more of them have is a connection to annual budget systems and financing. And I think that's quite a crucial component. More of the laws that are more recent start to have this element. Sweden is from 2017, Germany from 2019, the Spanish law from, is not yet adopted. So, the more and more draft laws and new laws are considering the integration of budgeting and government expenditure with the climate, the long-term climate goals, trying to make sure that they are compatible with one another. So that this is, I think, an important step towards mainstreaming the climate targets into other governmental policies. And I think future laws should basically pick up on that example and integrate more of a consistency check for other policies as well. Then reporting and monitoring, so checking on progress. Again, this is something where there are existing obligations for all countries that have been in place for quite a number of years, from the UN level and also organized at the EU level. So all EU member states essentially are used to reporting their data on an annual basis in any case. What is important here in the national laws, I think, is that basically if you have a government agency that compiles a data report and sends it off to some other agency in Copenhagen or Brussels or at the UN level, then that doesn't really create any accountability at home. And so what progress monitoring and national climate laws can do is create a moment for the government to actually be held accountable and say, so we've done our strategies, we put policies in place, here is our annual check on whether we are actually on track. And so that's why the progress monitoring is quite important at the national level. And this is done slightly differently in different countries. can differ in several aspects. One important one is who reports, for example, and what happens if there is a gap. First, on the who actually does the reporting, there are, I think, the laws in Denmark and France and Spain and the UK, where the annual report is at least partially done by a third party, these scientific advisory councils, which are I'll speak more to in a minute. And so there is already an external party that isn't directly government that is doing the assessment of whether the data shows that you are on track. So that enhances the credibility of the assessment. And then government is actually forced to respond in public or send a report to Parliament to say, this is what we are saying about the progress assessment. So, you know, it creates a moment of government having to own up its own potential shortcomings. And key also in this regard is, if you remember the earlier cycle, you know, if I, you know, go back the cycle from how well are we doing again to close this off towards targets and measures, there are a number of the laws have a specific trigger for additional policy action if the progress monitoring shows that there's a clear gap towards the target, that the current activities are inadequate. I'll be relatively brief about the remaining elements, so that we still have the possibility also to get to Slovenia and maybe to a couple of questions. The institutional setup, I said up front that this is something where governments need additional structures. They need more clearly assigned responsibilities. And considering this, it's actually surprising to see that a number of the laws that we analyzed actually have very little specification on who does what. A number of them speak to the government will do X and the government will do Y. Some of them basically put this all to a single ministry being in charge of having to carry out every task. But a number of them are more detailed and are saying this ministry is in charge, for example, of the strategy, this ministry is in charge of the annual reporting, etc. And also says all of them need to contribute. I think this is most pronounced in the German system, which also has these sectoral budgets. And that law makes every ministry that has a relevant policy dossier, so for example, transport ministry or the agriculture ministry, it makes those ministries responsible for meeting the emission reduction goals for its sector. Why is that so important? I think there's a clear risk here, at least in some countries where there isn't maybe a culture of you know, high-level government targets actually being followed through by everyone, that you could imagine a situation where a climate change responsible ministry, such as an environment ministries, you know, tries to get everybody on board, so the economics ministry, energy ministry, etc., to contribute and implement effective policies, but these ministries are somewhat reluctant to follow through. And you know, this is in part the situation that was occurring in Germany, and which is why the new law provides some guarding against that. But I think this risk could be applicable in other countries as well, that you don't have enough contribution from all relevant parts of government if you don't put it in your law that they all need to specifically contribute and find a way of ensuring that they do. What's important to see and encouraging, I think, that most countries very specifically see a role for parliament. Sometimes that's adopting strategies or plans. Sometimes that's adopting the annual report, or at least debating the annual report. And I think that's for transparency and accountability purposes, that's quite important. Then on the scientific advisory bodies, which are essentially a new element here, because they don't there's no EU law, for example, that suggests that governments should put these in place, which is why it's more surprising even that essentially all of the countries that we analyzed have used or put in place now a form of an independent scientific advisory body in some form. There are some, technical differences, such as in Sweden, it was mentioned, but there's, of course, hardly any detail in the law, and that was, the details were decided separately. That doesn't really take away anything from the main conclusion. It's only in the case of the Netherlands that an existing expert agency is now tasked with the roles that these advisory bodies have. In all of the other cases, it's basically a new body that's been created specifically for the purposes of supporting the procedures established under the law. And those roles can be, as I described earlier, helping with the progress monitoring, so a bit of a watchdog function. Then they can also help inform and provide an external perspective on science-related measures or more technical elements, such as suggesting technologies or policies to be included in national policy programs. And they can also help engage the public in some cases. And in almost all cases, they're almost exclusively made up of really technical and scientific experts. That's quite important. This is where the UK specifically, sorry, was somebody trying to come in? The UK Committee on Climate Change really stands out. I think it's the original form of these bodies that many of the others seem to be emulating and have inspired, and it still stands out in terms of its mandate, the fact that it has a dedicated budget that it can spend. It has a large secretariat of actual technical experts that can support analysis, etc. So of course, that's a crucial factor. Does your advisory body not only have the brains to do the work, but also the funding so that they can spend the time, etc. Public engagement has been is surprisingly little detail in a number of the laws. Some of them specifically have this built into their frameworks, but not always is this explicit in the laws. So this was one of the things where we were surprised to see that there was so little specification. This may be in some cases because there are existing laws that already provide for public involvement on an ongoing basis to any policy decision that's being taken. But there are some countries even that have a national stakeholder body for a national climate stakeholder platform of sorts. For example, one exists in Germany, one exists in Spain, and they are not referenced directly in the law. So and without us being able to determine why that is the case. What is, I think, encouraging in this context is that several countries are experimenting with what is now, I think, more broadly known as so-called citizen assemblies, a format being tried out in Ireland. That was a citizen-related body that was actually looking at a variety of policy issues, not just climate. Those are also meant to be carried out in the UK. A citizens' convention on the larger ecological transition was carried out in France, etc. There are several new attempts to involve a larger, broader part of society, to get them on board, to create awareness, to have them inform policy. But in most cases, this is not directly regulated in the laws. I will stay away from the other element that we have still in the report. I want to point out that we have collected the information on what are the good practice examples in a table format that you can find in the report that's hopefully quite well accessible. It is also included in the summary, not just the full report. And I'm now going to, as the last bit, I will apply this just a little bit to what I know about the Slovenian law. But I can also pause in between because I realized that I've been, spending a good part of 30 minutes with this presentation. So Judge, let me know whether I should take a break here.
I mean, I think you can continue and we can ask the questions later, but if someone has a question right now, as I said before, write it down or ask it now. But otherwise, I think you should just continue and we'll have the questions later.
Great. Okay. This is, I wasn't in a position to see the chat at the same time as looking at my presentation here. So I wanted to check that I wasn't missing out anything. So Slovenia, as I said, I do not know anything about the, your current politics. And I've only over the last 24 hours had a look at two different draft versions of the law that I was able to get a hold of. One was the version for public consultation from, I think, September / towards October of last year. And then a version that I assume was produced afterwards. It's like a second draft. And it's that second version that I'm largely addressing my comments to now. So going through the elements that we also analyzed for the other laws. On the target side, we have carbon neutrality by 2050, so a quantitative long-term target. But we don't have in the draft interim or sectoral targets directly inscribed in the law, which several others do have. But there is a clear provision that specifics for interim targets and also a sectoral breakdown should be developed through the long-term strategy process. And so they won't then have necessarily the same legal character and the same sense of bindingness since they're not in the law, but there is a process for developing them. And so, if one had a means of strengthening that, then there would be a process for actually government adopting these in some form. One of the things where I saw the draft has changed was a notion that actually 5-year budgets, so periods of 5 years with a carbon budget would be developed under basically a planning system through national climate plans. But I had some uncertainty about how this system would actually work. To my sense, there was a certain unclarity about the timeframes. When would this start? What is the first of these budget periods? How long into the future are they set in advance? Is this for the immediate 5 years, or is this for 5 years starting in 10 years? Clarifications, I think, would be in order to have a sense of, does this really constitute a process for continuously setting new interim targets? With regards to the how do we get there part, a long-term strategy to be revised every 10 years really is a central document in the draft law, which should include pathways, a breakdown of policy options, the interim targets that I already mentioned, and also a set of indicators to measure progress. So, that's I think quite a comprehensive mandate for a long-term strategy. It's as I said, not all of the other existing laws even have a distinct long-term strategy included. So I think this looks like pretty much up there with other good practices in this regard. And what I thought was quite important in this context, a provision that if government develops other plans and strategies, which of course it does on an ongoing basis in different policy areas, then those that could affect the achievement of the climate or the carbon neutrality goal, they would need to assess how they can be made consistent with the target. So that's a net zero compatibility check for other areas of government and other long-term strategies. That is, I think, a good innovative element. On the measure side, there's a separate climate plan, separate from the NECP, to be done every 5 years. And this is where the budget approach would be implemented. There aren't really any further specific measures, such as the ones that I explained included in France or Spain, or more specific mainstreaming provisions. But there's the general one on policy strategies. And then in terms of the progress monitoring, annual report, biannual projections, both of those are essentially EU requirements. And so not much, in terms of a new element there. This is rather standard, but two things here. One, trigger for additional action if progress is shown to be insufficient. As I said earlier, that's a good practice element that we picked out in the broad, roughly majority of other laws that we were looking at. And connecting it with my second part of this, the annual report is to be adopted in a special week, a designated climate week in the autumn, which is exactly the kind of opportunity that I was describing earlier. That's an important function for progress monitoring at the national level. Find an opportunity to actually shine a spotlight on whether there is progress or a lack thereof, so that there is some public debate and attention, and therefore government can be held accountable. In terms of coordination, it is relatively specific in that it says, a lot of the coordinating job for the key policy documents, such as the long-term strategies and the climate plan, should be done by the ministry that's responsible for climate change. But it also says that the other relevant ministries are obliged to contribute. But that's always incorporated in the articles on the different documents, and there's a separate article that says this is how governmental coordination will work, which there are in one or two of the other laws. There is also a scientific advisory body specifically established under the law. So this is where the Slovenian draft laws basically are continuing the series that we're seeing in the other laws, a separate council. And the mandate that it would have under the draft that I've had a look at is actually really quite broad, with the possibility to provide recommendations on all of the relevant policy documents, including specifically the National Energy and Climate Plan as well, plus there being the possibility that the government asks additional work of it, but also the possibility to do some proactive work on its own accord. A key question here is, where are the resources going to come from? To what extent are these experts being paid to more or less do a full-time or at least a part-time job for that council? This I wasn't sure whether this is clarified in the draft legal framework. And then with regard to public involvement, I mentioned that there's a lack of specificity in many other laws. Here in the draft Slovenian law, there's at least a specific mention that there would be 30-day windows for public consultations on the drafts of the long-term strategy and the climate plan. There isn't a separate stakeholder body created or referenced, and I think there's no citizen outreach or the likes included. So if I had to, and this is obviously based on versions of the text that have been produced thanks to Google translation services, and so not read by a native speaker, not read by a lawyer either, which I am not. But my take, just going through these elements, would be there are many good points and references to what we would also consider good practice examples from other existing ones, especially the strong role for the long-term strategy, the broad council mandate. But there are these uncertainties over this budget concept and how it would work. And this is quite crucial, because one of the key functions that you want for these laws to fulfill is really to connect the long-term objective, which, you know, right now 2050 is still 30 years away. Even if you're looking at earlier dates, such as Sweden has 2045, Finland has a new date for climate neutrality by 2035, so not that long term anymore. But you want to make sure that your policies that you're adopting in the space of the next 1, 2, 3 years, and the investments that are being started or considered in this time frame, that they are in line with where you want to go in the long term. So long-term goals, informing policies now is really the crucial function. And so there I am somewhat uncertain whether the elements included in the draft law are like sufficiently robust to ensure that is the case. You know, there is still a possibility to go into the EU law, but we will then be running out of time. So I'd rather see if there are any comments or curious questions or corrections. Maybe I'd be very happy for feedback on where maybe I've gotten wrong or understood the draft law in a way that it wasn't intended.
Thank you, Matthias, again. I don't see any question in the chat right now, but let's still give people some more time. But we've gotten a question on Twitter, actually, from Marco Amavor. I don't know if you have seen it already.
I have. Question of trust.
Yeah, that's the one. I can read it out so that also the other ones can hear it. In your analysis, did you take into account the level or impact of trust or lack of thereof? Did not see any reference in the report. In my opinion, trust is a crucial component in public participation and the effectiveness of any climate law.
Yeah, I think that's a very interesting point. So I wish I could actually have a conversation about it, because I would already ask for further clarification on the question. Trust by whom in what? Is it trust by among governmental institutions or governmental actors that the others will all participate and actually play ball and contribute? Is it trust from businesses, etc., that government policies or government declarations will actually be materializing in real policy and are therefore credible, and should they take government targets into account for their own business decisions or not? Or is it trust by the public in government and its institutions actually really being serious about delivering on the long-term targets? And I think so. It's very hard to answer the question in a very simple manner. We did not look at this specifically because I think basically trust is something that's created through relationships and through your sense of how credible and serious and stable are procedures and also the actors that are meant to be carrying out certain procedures. And this is why I think actually, if you have a law like this, you can, at least you have a government that has committed to saying, for example, every 5 years, we will put forward a new package of policies to deliver our goals. You have an annual opportunity to check, are we on track or not? The question is, do you trust the data that's informing that progress monitoring? But there are established procedures for this. There are independent external checks from the UN on the emissions data. So it's really hard to compromise these. So I think you can have a certain trust through the fact that you have procedures and regularity and frequency and opportunities for transparency and the possibility for involvement. And I think it's for that reason that we highlight the fact that there are these independent scientific advisory bodies, because they help with making governments honest, if you will. They help with better information, better data, and transparency. And the same is true for opportunities for public involvement and for data and reports all being made public. All of that contributes to trust in these systems. But I think many people who are, would be at least logged into this, they have their own experience with engaging with stakeholders, engaging with governments as stakeholders or NGOs. So, you will have your own relation to this topic.
Okay, thank you. I don't know if we have time for another question. So before you were talking, you just said that you also wanted to talk about European climate law, and also the insights from the report can also inform the debate on EU climate law. And since it was published recently, could you give us a really brief comment, your comment on EU climate law?
So yes, I can try. I'm sorry that I've talked everybody into silence here. I hope we get a chance for further exchange and discourse on some other opportunity. But let me then jump briefly to the EU level. Oops, I still have to figure out the technology again. So, I mean, you will essentially all know that Ursula von der Leyen already basically made this commitment to the European Parliament as she was putting herself forward for election, that she wants climate neutrality by 2050 for Europe, and she wants to put it into a European climate law. So this was a key announcement, and she said she would do so in the first 100 days in office. And so this, as part of the new, overall conceptual framework of the European Green Deal, this is a key element. And it was only yesterday that the proposal was put forward, which is still within 100 days. And it's in the form of a proposal for a regulation. And it says that it would be establishing a framework for achieving climate neutrality. And the short version is European climate law. Now, we basically went through what European legislation already has on targets and on planning and measures, and we checked, to what extent could this be improved, also keeping in mind what's in the national laws. And one of the key things that the new proposal was meant to do was enshrine the long-term target in law. And that's actually something we didn't have in EU legislation thus far. So we didn't have the 2050 target in law. We don't even have the 2030 target as a whole really in law, because we have the division of the climate target into emissions trading system and non-emissions trading sector targets at national level. We also don't have interim targets, or we don't have a process for setting interim targets beyond 2030, despite the fact that the Paris Agreement very clearly establishes a 5-year process for reviewing contributions to the UN system. So the EU has some improvements to be made with regards to targets and target setting. And something that's been put forward by my colleague is this notion that the new law could also spell out the target in the form of a carbon budget for the EU up to the middle of the century, so that because that is essentially what's most important for the atmosphere, are cumulative emissions. With regards to the planning process, I've mentioned there the long-term strategies and NECPs for member states. For the EU level, we do have an EU 2050 strategy, or a proposal for one. We don't have in the legislation anything for a review, or like every 10 years, for example, with updates after 5 years that the member states need to do. There's nothing like that for the EU as a whole and for EU-wide strategy. And so that's a gap that could be filled. And then it's of course of key importance that other policies are also aligned with the long-term targets. So mainstreaming is a key issue. And then with regards to monitoring, there's already a pretty strong system in place. And with regards to the coordination, there could be stronger involvement of the European Parliament, for example. And with regards to further involvement of other actors, of course, the EU could also follow the member state lead and establish a scientific advisory body. Of course, it already has agencies that can in part perform that role, such as the European Environment Agency, but that's not necessarily the same as a body that's specifically created for the purposes of, say, monitoring progress and providing ideas for climate neutrality achievement. And so what's actually in the proposal, you know, this is super brief, because I recommend having a look at the actual proposal. So the climate neutrality is actually not carbon neutrality. I think it's climate neutrality is in there. There is no there's no quantitative target for 2030 or a proposal for 2040, but there's a process for considering an increase in the existing 2030 target. What is included is that a separate article is inserted that would give the Commission the power to develop a trajectory after 2030, which essentially would mean, to my understanding, you know, interim targets towards climate neutrality after 2030. And this would, on the basis, the proposal says this would be done through delegated acts, meaning not through a normal legislative process, but the Commission proposes, and then Parliament and Council can say yes or no. But it's a take it or leave it option. And if they reject it, then the process gets restarted, or, you know, needs to go into conciliation. I should know better, and I don't have the details. In terms of planning, the long-term strategy that I mentioned doesn't have a review in the legislation just now, not really being mentioned at all. No review process in the law. I think that's a clear gap that hopefully will be addressed by Parliament or by Council in the negotiations. With regards to measures, again, there isn't an equivalent of an NECP, like an EU energy and climate plan, for example, to identify where additional measures would be required at EU level. That does not exist, but there is an assessment process that sounds like it could lead to proposals for new policies if there isn't enough progress. And there is, similar to what's actually in the Slovenian draft law, a more general provision on mainstreaming, but it applies not just to strategies, but to measures and legislation, new measures and legislation, which the Commission is now meant to always have to check against it being compliant with the climate neutrality objective. But it's a check and information. It doesn't say these laws can then not happen in that form. It's just a matter of you're getting an impact assessment done against climate neutrality and providing that information. No new scientific advisory body created. Obviously, you know, the EEA, which is already important in supporting many of the key governance function on climate policy, is also requested to support the Commission here in this form. But there is, not surprisingly, the Commission, at least, which usually has that role of doing the analysis, has not suggested that a new independent advisory body would be created. With regard to public engagement, there is a separate article on this, and it calls for a very broad mandate that the Commission should really ensure that there's an inclusive and accessible process at all levels to provide input. So that's in part, that's left a little bit vague, but there are changes to existing laws just to try and implement that a little bit. So, but I would take it more as a statement of intention and not a very specific public engagement process.
Okay, thank you, Matthias. It would be really great to go on with the discussion, but we have next meeting scheduled at 2 o'clock, and we're already past that, so we'll have to stop at this point. Thank you very much again, and I hope that we'll be able to organize another meeting, webinar, or something like that to further the discussion and so on. So thank you.
All right. So I really appreciate the opportunity, and I hope that despite the silence from the audience, that those who stayed you know, got something out of it, and I appreciate everybody's attention and spending this hour with me.
Okay. Goodbye, everyone. Thank you
Bye-bye.
for joining. Bye.
Bye bye.
Bye.